Welcome from the heart of Munich at the Data Protection Café. Today's topic, deleting employee data. When do you need to delete which data in the company? There are data of employees, data of applicants, and data of former employees. And we will take a look at the exact framework conditions in today's video. The principle also applies to the personal data of employees that these data must be deleted when the purpose for which they were originally collected no longer exists. In the present case, we differentiate into three categories: applicants, current employees, and former employees. The following principle applies to applicant data. You are allowed to retain the data for 6 months, also to defend against claims under the General Equal Treatment Act, AGG. If you desire to keep the data for a period longer than 6 months, for example, due to the need to establish a pool of applicants, you must obtain the prior consent of the respective individual. Then we look at the current employment relationships, and there is a pivotal decision. There exist two camps that advocate different approaches. One camp asserts that employers must continuously delete information from the personnel file and remove data that is no longer necessary for the sake of efficiency and compliance with data protection regulations. The opposing group relies on the case law of the Federal Labor Court in the Emmely case, which is also linked below in the description. According to the Federal Labor Court's argument in this Emmely case, when assessing the legality of a termination, all details of the employment relationship can be taken into account, as stated in the provided link to the Emmely case in the description. As a result, the employer's side concludes, conversely, that there would be a right not to have to constantly delete information from the personnel file, but rather to keep all potentially relevant information for the employment relationship stored in order to be able to make decisions accordingly in an overall view. Lastly, we cannot overlook the data of former employees, as it is vital for our records and analysis. The principle that typically applies is that usually 10 years after leaving, there are no longer any tax-related obligations for data retention, and the data should be deleted accordingly. Life is not about waiting for the storm to pass, but about dancing in the rain. And now, to conclude on the topic of deleting employee data. Employers need to differentiate between the various phases, such as the application phase, when the employee is hired, and the termination of the employment relationship. Particularly with regard to data storage in the employment relationship, there exist two opposing camps and, accordingly, ample room for employers to decide how to intricately design the deletion of data in detail. What else has occurred in data protection? It has been demonstrated that hackers from North Korea are focusing on researchers in the field of information security. Link in the description. Thank you for watching.